All right, now let's move to what's going on just as far as human resources is concerned. Joydeep Hor joining us from People and Cultural Strategies. Joydeep, great to see you there. We're going to talk McDonald's and more broadly class actions because now there's a class action filed on behalf of McDonald's employees who were not given a paid 10-minute break when working a shift of 4 or more hours. What's the backstory here?
Yeah, so firstly, class actions in an Australian context are few and far between. And it's quite interesting because as a case like this shows, if you've got an employer like McDonald's, Coles, Woolies, and any number of large employers that would have a pretty significant casual workforce, that would have people as young as 15, 16 who are working odd times throughout holidays and all sorts of things. But more importantly, most of these organisations would have reasonably detailed obligations as employers in relation to the specific terms and conditions of employment under which those employees have to be engaged. Now, what employers tend to focus on is they think about the big ticket issues. They think about pay rates. They might think about broad holidays and things like that. They might even think about rest days, but in their mind, they are thinking more about what they would consider to be very much the big ticket items. But in most of these enterprise agreements that are binding on employers, a whole range of industries and across different sizes, there are going to be a lot of provisions that could best be described as finicky. And this is one such example. So an obligation that exists in the McDonald's enterprise agreement, recognising that this enterprise agreement is binding on every McDonald's store around the country, regardless of whether that's owned by McDonald's or whether it's a franchisee or whatever it might be. And it's got a provision in it, and it's not an unusual provision that says, well, look, if you're working X number of hours, you're entitled to a break of 10 minutes. So if you're working 4 hours, you're entitled to a 10-minute break. If you're working between 4 and 9 hours, you're entitled to two breaks of 10 minutes. And what happens in practice is that in the cut and thrust, some might say, of actually delivering the burgers or the shakes or fries or whatever it might be, these are things that are often overlooked or, perhaps looking at it more sinisterly, disregarded by the employer or by management at the particular store, thinking, well, that's not really that important. What's a 10-minute break here and there? Maybe I'll just let the person finish a bit earlier at the end of the day and I'll make it up to them somehow. But the problem is for employers in this situation is you are expected to comply with your obligations in an enterprise agreement to the letter. And if you play out a scenario like this, and the case is being run by a law firm that does do particular work in this space, they've extended an invitation to every McDonald's employee around the country. Say, look, do you fit these particular criteria? Did you work at a time in 2021? And there's a whole range of questions. And if the answer is that yes, we'll just lob your name onto the class action. And the reality is this is going to be a technical analysis as to whether or not the particular employers, who might be the different employers at these McDonald's stores, complied with their obligations under that enterprise agreement clause.
What does that do for a case if you try and sweep up as many people as possible? Is it sheer weight of numbers, particularly in the service sector, where a law firm takes on the case and says, right, let's just get a volume there? Is that important to the case?
It is important to the case for a number of reasons. One is it means that the profile that will attach to that litigation is naturally going to be a lot more significant. More importantly, though, if you bear in mind that the actual dollar shortfall arising from a paid break not being provided in respect of each individual employee might not be that significant. So in order to make this a significant money claim, you're going to need that multiplier effect of a significant volume of employees. And so, if you're the law firm running a case for $100,000 might be one thing, but if you're running a case for $1.5 million against McDonald's, well, all of a sudden that's a much more significant piece of litigation. But also what that does is it means that the level of interest in this case from those employees is going to be significant, and probably most significantly, it might lead to a situation where any of those individual employees, through the course of their participation in these proceedings, may identify other matters where they consider that the agreement has been breached. So all of a sudden you might find a number of other things unraveling, which is another reason why the more people you get, the better.
And I would have thought it would maybe hard to quantify. We're just talking 10-minute break, whether that's cumulative or how that's actually recorded when these people go to work. I mean, is this commonplace in the service sector?
Look, non-compliance with breaks is quite commonplace. And in fairness, we've had a lot of clients who said to us over the years, yeah, look, I mean, by the book, we know we probably should have done it differently, but it's not like we forced this on the particular worker. Often it was a quasi-collaborative process, or there was the agreement of the individual employee, and they've said, look, I understand we're busy right now. I'm happy to forego my break. But unfortunately, if you're an employer in that situation, you've got to have a different approach. You've got to look at the letter of the law as set out in these enterprise agreements as being completely binding. There's no wriggle room. And even if you've got the goodwill and support of employees at the time, you've actually got to approach it differently.